Put simply, the Stock Act is intended to ensure that members of Congress do not profit from trading on insider information. And press reports on 60 Minutes and elsewhere have raised questions about whether lawmakers have been exempt, either legally or practically, from the reach of our laws prohibiting insider trading. At a time when polls show record-low public confidence in Congress, there is a strong desire on our part to address the concerns that underpin the public skepticism and assure the American people that we are putting their interests ahead of our own. The Stock Act is intended to affirm that members of Congress are not exempt from our laws prohibiting insider trading. While several of the witnesses who appeared before our committee's hearing on this bill testified that there is no legal exemption for members of Congress, confusion and uncertainty nevertheless persist. For example, on the eve of our markup, the Wall Street Journal published an op-ed by a Yale law professor who wrote that, quote, "The Securities and Exchange Commission has determined that insider trading laws do not apply to members of Congress or their staff," end quote. This, however, is directly contradicted by the statement for the record submitted to the committee by the SEC's enforcement director, who said, quote, "There is no reason why trading by members of Congress or their staff members should be considered exempt from the federal securities laws, including trading prohibitions," end quote. To me, this illustrates the confusion over this issue. So I'm pleased that the committee not only reported Senator Brown's bill, but unanimously adopted an amendment that I offered with Chairman Lieberman that states clearly that members and their staff are not exempt from insider trading laws. The need for this unambiguous statement can likely be traced back to the nature of the insider trading laws. As our committee has learned, our nation's insider trading laws are not, generally speaking, based on statutes passed by Congress, but rather on court precedents. As one of our witnesses, a law professor from Indiana University, pointed out during our hearing, Congress has never enacted a federal securities statute that explicitly prohibits anyone from insider trading. That explicit statutory ban on insider trading is entirely absent in U.S. securities law. I believe that we need to reassure a skeptical public that we understand that elective office is a place for public service, not private gain, that it is an honor and a trust that we have been given by the people that we represent. Underscoring that important message is clearly the intent of this bill, and that is why I support it.